Welcome back to More Moss to the People. My name is Asa Nilsson, and I am your host. Today, I have a very, very special guest on, all the way from Boca Raton, Florida, and she is actually my sister-in-law. Now, I'm not married to her brother any longer, but she is still my sister-in-law. She's still my family, and interesting thing is, haven't seen her in years, 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 and I have been thinking about, I really want to get an attorney to come on and talk about important documents that we can think about to prepare for our deaths. Because, I love to talk about Swedish death cleaning and decluttering of our lives. And then I found out that this sweet angel works with this for her profession. And so I have reached out to her and she so graciously accepted my invitation. So welcome, Angela Klemack Santos, to More Moss to the People.
Hello, it's good to be with you. This is great.
Oh my God, it's so fun. It's so nice to see you. It's a pleasure to have you here. Thank you.
And the pleasure's mine too. Love it.
Thank you. Thank you. Thank you. Please tell us, who are you in the world today?
Oh, it's such a complex question.
Mm, mhm,
But we'll make it simple. So, I'm a mom. That's my
mm,
favorite job as of
mm,
now. So I have two kids,
mm,
8 and 9, and I have a spouse,
mhm.
and he's terrific too,
That's good.
keeping them quiet while I get this done. And then I'm also an attorney.
Mm,
And specifically as an attorney, I do trust and estate and tax planning. Now, my clients tend to be um, of a wealth that I would never have myself, and I typically would never use the type of services that I provide for them in terms of the tax pieces. But every person, no matter what your wealth is,
mm.
will need some I'm going to call foundational estate planning documents to prepare for what we know will someday come.
Mhm. Hmm.
And that's what I do.
And what an interesting, I have to ask you, how did you get interested in that avenue of law?
Yeah. So first I was interested in tax.
Mm,
I was fascinated by how certain policies, tax policies, can influence behavior. So that was kind of how it started. And then as I got more into tax, I got exposed to personal private client tax and tax planning. And the piece that I loved about that um, tagged on to trust in the states, where you're having very intimate and personal
mm,
discussions with people about, maybe their privately held business, which is like a baby to them, their families, maybe you know, children from multiple marriages, and how you
mm,
handle this and that between complex family dynamics, or sickness, special needs. Drug
mm.
addiction comes up so often.
Oh,
So all these intimate issues, very private and complex, and handling them, and at the same time, you're providing them tax advice and estate planning advice, but also some, I think, personal counseling as well.
yeah, yeah,
It's really terrific when a client calls you more than just for what you do as an attorney, but for advice on, how to
yeah.
handle a certain family issue or
How
things in that
interesting.
regard.
Why
So,
is drug addiction so relevant or important or in the
yeah.
mix? That's that
Um,
common?
you know, it's certainly is in South Florida, or maybe the
Uh-huh.
States. Kids just more and more, I think, get tied up with drug use,
Mm,
and in particular when they come from affluent families.
mm,
um I don't know, perhaps it's more common there, but it certainly is in the clients that I advise, where they typically, or often, I shouldn't say typical, often have a child that falls into circles that you
yeah.
would prefer them not to be in.
Mm, mm, Yeah, no, I don't think that it is United States only. I think that is, I'm sure, across the world where people who have access to anything um,
Yeah.
potentially can and do access it. So, All
Mhm.
right, we're gonna come back to I wanna come back to all of this because this is so fascinating to me because, the idea of Swedish death cleaning and preparing for your death. A lot of people get worried when I talk about that. They think there's like some kind of voodoo about this, and it's not a voodoo conversation. It is really like you said, this is like, it is a very private, intimate conversation because every single person handles death differently and certainly handles their financials and their whether they want to look at them or look at things or not. But, for you to get involved in somebody's life or for somebody to come to you saying, "Hey, please, Angela, we need your help as our estate planner." What I think is nice, it's like it's designing what you're doing is you're helping families design an estate plan. And so, designing an estate plan could be like designing your future life and what do you want it to look like and having this be a part of your future, like your life and how you want to feel settled now, have peace in your life today so that you can think, okay, well, maybe I want to do this one day, or maybe I'll be able to do this for my family, whatever. But that starts with getting paperwork in place. Now, I do want to say a caveat for you listening. I will mention the name of the company that you work for, and I'm going to say a quick statement. The name of the company is Katz, Baskies, and Wolf in Boca Raton, Florida. And Angela's comments and views are hers alone and do not represent the firm. So we want to get that out there right from the beginning, get it out so we know we're having a conversation, a chill conversation between two sisters. And I have questions, and I know that you potentially have answers for us. And I want to be able to just ask you, what do we need? I mean, I'm 57 years old nearly. How do we get started? How do we get started preparing for
Yeah.
this? Help
You get
us.
started by thinking about what's important to you.
Mm,
And it could be, certain values that you want, the people that you'll leave behind to take with them,
mm,
or it's a little more tangible. You have maybe certain things
mm,
that you want to leave behind, and in a certain structured way. So if it's
mm,
something, you know, maybe something special, a family heirloom that you want to handle in a certain way, or if it's just, what happens to my house, what happens to my financial accounts. All of that is part of the conversation, and you'll need to decide, where do you want things to go,
mm,
and who do you want to be in charge of executing on that for
mm,
you.
mm,
So the two documents that come into play in making those instructions are the last will and testament, and often what we call a revocable trust, which you may or may not need, and I'll tell you why when we get there. But I'll say that more modern estate planning will have both of these documents. They work together. A last will and testament, which we often then call a pour over will because it pours over into your revocable trust.
mhm,
And then the revocable trust is the primary instrument then that has all of your distribution provisions in it, and even some of your perhaps values or certain things that you want to express to those that are, inheriting from you.
That goes into a will? Your values would go into a
It
will?
can.
That's
It
interesting.
can. So if it's the modern approach with with the combo of will and
Mhm.
trust, you'll typically find those provisions in a trust because the trust remains a private document. It's not filed
Uh-huh.
with a court.
Okay.
The will is filed with a court,
Mhm.
which is another reason why you might go for this kind of combo setup. The will being filed with the court, for privacy purposes,
Mhm.
you might want to, keep those distribution and certain um, wishes or intents or values private.
Okay.
Um, and second, once you create this trust, and this type of trust, you can retitle assets to it now, today. And the purpose for doing that is so that any asset you do retitle avoids probate after
Mhm.
you pass away.
Mhm.
And probate is the legal process supervised by a court. Um, that has certain particular steps to it, and it often delays the ultimate distribution of the assets to the persons that you want to get them. It has a cost to it.
Mm.
So there's plenty of reasons, if you can avoid it, to try to avoid it. And there's
To
different
avoid
ways to do
probate.
that, which we can talk about.
But can I ask you, what's the difference between, I've heard of an irrevocable trust. What's the difference between an irrevocable trust and a revocable trust? Is there a difference? Is there
There
such
is
a
a
word?
difference. There
Okay.
is a difference. Yeah. So the one I'm talking about, a revocable trust, um, its primary function is to serve as a will substitute, meaning it takes over all of those distribution provisions after you pass. But it also serves for incapacity planning as well. Um, Meaning if you get to a point where you can no longer handle decision making or your
Mm,
finances properly, or perhaps you can but you just don't want to do it. Maybe you don't want to put your energy there. um, the successor trustees that you designate under this trust will have the authority to do that for you, to the extent that you retitle assets into the trust. um, and this actually works together with another document called a durable power of attorney.
okay, so hold on, I gotta go backwards now.
Hmm.
Is is the executor of the last will and testament then the same person that is, or people that are taking care of the revocable trust? Or can they be different?
They can be different and they can be the same.
Okay,
So that's your preference.
okay.
For whoever you name as an executor under the will, that person has mm, typically more of a limited job in that it has a beginning and an end.
Mm,
If you need probate, the executor is the person that's responsible to lead that effort.
okay.
And they open probate, they follow the directions under the will, they pay, last debts, creditors' expenses, file your last tax returns,
Mhm,
and then after everything is distributed and handled, it's closed. And that's the end of
done.
probate. The revocable trust and the successor trustees under that instrument potentially have a much longer role depending on how you design the trust.
Mm,
And in particular, if you have children or other family members where you want to give to them, but you want the protection of a continuing trust for them. So under my document, I might say, I don't know, 30% to ASA in trust for her lifetime. And then I get to describe how you get to use those assets,
mhm,
typically with a lot of flexibility, but still that with some limitations that you still have the protection of a trust, protection for some tax purposes, and also for creditor protections, are also all benefits to you in having those assets in trust. So that successor trustee in the revocable trust, their role could be, as trustee of the trust for ASA under my trust for her lifetime. And you also would name, of course, successors,
right.
maybe two or three, just in case, it doesn't work out, or the
Mm,
trustee passes away.
yeah.
Um,
Or they don't
but
wanna do it, can
the
they say, "I don't want to"?
or exactly, they can decline. They can
Mhm,
absolutely decline.
mm,
So that role of a trustee is potentially a longer role with a more significant relationship with whoever the
mm,
beneficiary is of the
okay,
trust.
okay. Okay, and so then you went into a durable power of attorney, and what does that mean? What does that document?
Yeah. So the other documents that kind of round out our foundational estate planning documents are durable power of attorney and the advanced health directives.
Mm,
So durable power of attorney is a is an instrument where you, as the principal, designate an agent to serve as your attorney, in fact, or agent under this instrument. And it's a financial instrument where if Like, and if you become incapacitated or unable to handle your own finances or pay your bills, this is the person that then, with this instrument, goes to your bank and says, I'm Angela. I'm the agent for ASA. I need to have access to her account so I can start using her assets for her benefit, whatever
Okay.
your needs are. So they take over your bill pay, they take over whatever type of financial responsibilities that you have with that instrument. Now, an important distinction is if you have a revocable trust and if you have a durable power of attorney, you have to be sure to understand who has the access over that particular asset, depending on how it's titled. So if you've already
Mm.
retitled, say, a brokerage account into your trust,
Mhm.
the durable power of attorney does not have any authority over that account. It's the
Okay.
successor trustee for that account.
Okay.
But if, for example, you have an IRA or other retirement account that while you're alive, you can't retitle it.
Mhm.
It's your durable power of attorney, the agent there, that has the authority over that asset because it's
Mm.
not in the trust.
Mhm, mhm. And why
Okay, so it
couldn't you put an
depends.
IRA in there? You can't
So
rename
while
it
you're
an IRA?
alive, yeah, while you're alive, you can't retitle an IRA.
Okay.
Instead, that's the type of asset where you designate a
Yeah,
beneficiary to receive it after you pass away.
right.
So often, now, if you have the trust, your new designated beneficiary should be your trust. So
Mhm.
it'll go over to the trust upon your passing, and then the trustee adds it into its distribution scheme and instructions
Into the pot.
into the pot.
Okay, alright, and then what about the advanced health directives? That's if you are completely incapacitated.
Right.
Mm,
Either incapacitated or for some reason, you otherwise can't speak for yourself. So those typically involve three different elements. Um, in Florida, we call it a designation of healthcare surrogate. Some other states call it a healthcare proxy.
mhm,
So there's variations on what they call it, but it's a healthcare surrogate that you designate to make health and medical decisions for you in the event you can't speak for yourself.
mm,
And it can be because you're incapacitated. It can be, um, you're incapacitated only because you're in the middle of a surgery and you can't speak for yourself.
right.
But it's not the circumstances where you're incapacitated and your body's dying. That instrument is different. That's called a living will.
Okay, yeah.
So the living will deals specifically with those circumstances where you're incapacitated and you're under either a vegetative state
Mm,
or you have a terminal illness and there's no hope for recovery, and essentially your body is starting to shut down.
mm,
And then what? And
mm,
the living will designates that person to make those end of life decisions.
mm,
And there's two important elements to that. One, you get to dictate what type of life prolonging measures would you want withdrawn. So
mm,
very often, for a lot of people, it's everything.
mm,
No feeding tube, no water, um, or hydration. None of those elements that would only prolong your
mhm,
life. Instead, usually or commonly, the person is then shifted to hospice and comfort care,
mm,
and then you let the body go naturally.
mm,
That's the most common way to handle the scenario. But I've seen hydration, against certain religious values. Where yes, I don't want to be on a ventilator, but I do want hydration.
mhm,
Um, and
mm,
then the circumstances of, is this in fact a situation that is end of life? This is the most critical decision for the person that you've designated, because they need to still be your advocate for health,
mm,
but still be sensitive to is this the thing that's taking your life? And a good example that we all, are familiar with is COVID, where individuals were on a ventilator for months,
Mm,
months. And physicians were saying, okay, we don't think, Asa's going to survive this. She's been on the ventilator for 3 months. We think it's time to withdraw everything. And there's where your surrogate comes
yeah.
in to say, yes, okay, let's withdraw and see what happens.
Mm,
Or no, let's give her more time. Let's see if her body can still heal from this.
mm,
And let's wait it out a little more.
mhm,
That's the sensitive piece of this type of instrument. So COVID is one that makes it a little more challenging. If it's something like stage 4, pancreatic cancer, and this sort of thing, where there really is, no hope for recovery. This will be the disease that ultimately takes their life. That perhaps is a little more or easier to distinguish.
mm.
But there are certain events that aren't so obvious in
Yeah.
terms of end of life.
I mean, talk about having I mean, that's an important document, right? I mean, to think
Mhm.
about the person that is gonna be having to make these decisions for you. So this is not something that you take lightly. I don't think any of these documents are anything that you would take lightly, my god. But I think that it is what if I'm just gonna say this, what if you don't do any of this? What happens?
Yeah, so things can get pretty complex. If you don't have a person designated in a document, now your physicians are going to be trying to find next of kin, closest person available, which may or may not be the person you want making these decisions.
Mm,
And what if they can't even find that person? Or what if they're overseas?
right.
Um, Now you can potentially have either the physicians making these choices for you,
Mm,
or if there's any kind of conflict um, between either the hospital or physicians making these decisions, they have um, in hospitals there are persons, social workers primarily, that petition a court that say, I have Asa here and I can't find next of kin and we need medical decisions made. And we, the hospital, are petitioning the the family court on her behalf to appoint a guardian for her care and all of these decisions. So now we're involving a court process
mm,
where the court reviews, and then um, uh, court systems have public guardians actually just on the ready for this.
strangers?
So
Complete strangers that are gonna be
complete
making
strangers,
decisions. Yeah.
complete strangers that the court will designate
Mm,
to step in and
mm.
make these decisions for the person.
Okay, yeah, no, I'm
So
pretty sure I don't want that.
all of that should be avoided,
Yeah,
and they're relatively simple documents to do.
yeah, yeah. Well, what, like, so say, for example, you don't write a will. You don't write a will. Like in America, I mean, obviously in Sweden, it's different because if you have children, your children inherit you. I mean, don't matter, you can never uninherit your children in this country, which I think is pretty interesting. But in America, where you are, um, what if somebody just dies and they have nothing? They don't have a trust. They don't have a will. They don't have any like nothing. Like what just happens? What happens with their stuff or their
Yeah,
money? Or does it just go someplace
yeah.
again to strangers, or where does it go?
Probably not to strangers, but it depends who
A
you have
fund.
surviving you.
Mm,
There are default laws to deal
mm,
with this situation, and the U.S. has it, and I would say almost all the countries have some kind of default laws to deal with this. Um, the U.S. does not have forced airship. Sweden, what you
mhm,
just mentioned, is an
mhm,
element of forced airship. There are some jurisdictions, some countries that have that forced airship, meaning X percent must go to,
mhm,
this survivor. Um, the US doesn't have that except for a spouse.
mm,
You cannot disinherit your spouse
mhm,
totally.
mhm.
They would be entitled to, in Florida, 30%.
Okay.
So it's typically around 30% or a third of your estate.
Mhm.
must go to your spouse
No matter what.
unless you have some kind of prenup or postnup where they waive it.
Mm.
So no matter what, yes, the spouse gets 30%. Other than that, there is no other uh, forced heirship. So the default rules then come into play. So if you have no documents, none at all, um, your assets will follow the intestacy scheme. So this is just a statute on the books that say, if Asa passes away, if she's survived by certain persons, this is what happens to her stuff. First of all, if you have a surviving spouse and no documents,
Mm.
it's 100% to the surviving spouse.
Okay.
If you have a surviving spouse, but you have children of another marriage, then we have a different scheme where
Mm.
typically it's half to surviving spouse, half to the children of another marriage. And there's variations on that depending on jurisdiction.
Right.
And if there is no surviving spouse, then it's 100% to the children um, in equal shares. And if not children, then we get down to grandchildren. And if there's still none, then we're going to go up your bloodline.
Okay.
So
Then it
if
goes
there
up.
is no spouse, yeah, if there's no spouse, there's no children, we're going to go up to parents.
Okay.
And if there's no parents, then we're going to go to siblings.
Oh,
So it's following
okay.
this kind of ancestry tree
Yeah.
to find your closest blood relatives.
Mm.
That's the goal of the default legal rules if you do not have
If you do
a will.
nothing. Yeah. Well, this just says so much for people that if you can if you can make choices now, why not make them now? Right?
Make
Why
them now,
put
and in
off
particular,
what I mean, would if you can make the decisions versus having a court make decisions for you, or God knows, some random stranger that gets appointed. I mean, um, what are
or
you?
perhaps your loved one is not part of those rules.
Yeah.
So
Yes.
maybe you're not married, but you're in a committed relationship. That person doesn't take
No.
under that scheme,
No.
or your best friend in another country won't take
Yeah.
unless you specifically
That's
name them.
right. Gosh, that's so right. So let me ask you, like, people who like want to make their plans for their funerals, or because I love this stuff too, talking about, okay, well, how do you want your funeral to look? Where do you want, like, I mean, the digital nightmare, right, of everything, the social media, all these different things, that has nothing to do with what you're working with. That doesn't go in with the will. That doesn't go into any trust information or anything like that, right? That's completely separate.
No, not exactly. So when you prepare these documents, the will instrument and the trust instrument um, give specific access to your digital assets.
Hmm.
So it'll authorize whoever I designate as my executor or successor trustee has access to these items if they request it.
Mm,
So that's an important piece.
mm, yeah,
Um, how
it's.
they have that information, that's really on you yourself
Hmm.
to prepare. I would say, you know, a journal of all of these types of
Right.
digital assets or account information, logins, passwords, all of that in a place where it can be located.
Mm, yes. My sister just lost her husband in at Christmas time,
Mhm.
and the just the amount of work that she had to do after the fact, getting things into her name. I mean, for her own home, like just changing
Yes.
things over, and it's so much. And I mean, I recommend to anybody to just really start having conversations around these types of documents, and and if you can't afford an attorney to do this type of work for you, do you, like, I know Susie Orman has some kind of a kit that she sells for people, like $150 or something like that, for documents for your death. I mean, so she made it affordable, but you have to do it yourself. Like, there's no attorney involved at all unless you hire an attorney. Would you recommend that something's better than nothing? Would
Yeah.
you recommend that, or would you say get an attorney to do it right, do it properly, spend the money, and pay somebody for a couple of hours of their time to do the documents or however it works.
Yes, I definitely agree. Something's better than nothing.
Mm,
If your wishes tend to align with kind of what the law seems as predictable, spouse, children, blood relatives, if you fit into that scheme, then one of these kind of kits is
yeah.
probably just fine.
Mhm.
If you have a situation that perhaps is a little more complex, um, you know, because you have persons that you want to take that are not blood relatives, or you have blended family
Mm,
situations, there I would say just get an attorney to
mhm,
review that for you,
mhm.
or to prepare it for you.
Yeah. Yeah, because it's a small price to invest, I think, in having things done properly. Uh, I mean, I've met with an attorney here in Sweden for Thomas and I to have our will done. And, as an American, I am an American citizen and a Swedish citizen. And I'm like, do I need to have a will in America too? Or do I have the one in Sweden? I mean, how does all this work? And I mean, I would never have known that. See, now that is something that is abnormal. So I need to talk to an attorney because there's something strange. There's something I need to get counsel on. So, that's an example of something that might not be what everybody else has, but to have the medical power of attorneys and to have these things, it's so important because anything can happen anytime. We know this.
Right,
We
right.
know this every day. Every day these things happen in our lives and we're like, yeah, I really got to get on that. I really got to start doing this paperwork. The time is now. The time is,
The time is now.
yeah.
And the peace of mind that
Hmm.
you have
Yep.
after these documents are signed,
Yes.
um,
You can
is
always change them. I
it's
mean,
worth it.
and
You
that's
can
the
always change.
thing.
Yeah,
Yeah, and that's what people are like, "Oh, well, I don't know. I mean, I'm 57 years old. I don't know what I want when I'm 90." Well, y terrific if you make it to 90, but I mean, these are things that can be changed. And,
yeah.
to name people, ask people, you don't just name somebody to be your executor, please. You please ask them if they would be willing to do it, because what a horrible surprise, right? Oh my
Right.
god. Guess what? No, no. All right, I know our time is already up. I knew this was gonna go so fast because 'cause I'm so fascinated by this this part of our lives because I've seen too much, especially recently, too many people dying way too young and nothing being in place, and it is not easy for the people that are left behind, I'll tell you. Do you have any any other things or a little tip or anything for anybody that like spontaneously just pops into your head, anything that you want to share as your parting gift? Your parting
Uh,
gift. No
well,
pressure.
yeah. um, So, yeah, one thing to keep in mind, which is easy estate planning, easier than preparing wills and trusts, is certain assets that are the type that can pass automatically to somebody without need of a will, without need of any document at all. It's just by titling itself, it can pass automatically. So those types of assets are um, real estate. So by deeds, if it says
Mhm,
with right of
mhm,
survivorship,
mhm,
passes automatically to the survivor. Um, in some jurisdictions, we have what we call a ladybird deed. It's also an enhanced life estate where it's 100% in the name of Angela, but upon Angela's death, it's to friend Asa 100%, kind of like a beneficiary designation in a
uh-huh,
deed, in a real estate deed. So that could
okay,
be an option.
okay,
That
uh-huh,
would pass automatically. No need for probate.
nothing.
Um, and then certain financial accounts that, if there's an element that it could be added, that is pay on death or
Mhm,
transfer on death, you'll see
mhm,
TOD or POD.
mhm,
Those are often elements that you can add to an account so that upon death, that account passes automatically to the survivor. No need for probate. Um, and then, of course, your beneficiary designations, typically retirement assets, life insurance
mhm,
policies will have
mm.
a beneficiary designation where that too passes automatically to the survivor. No need for probate. So all of those can be passed without even preparing a will.
Yeah.
because they pass automatically by the titling
If
itself.
they are titled properly. Now, one thing
Right.
I do want to add is a little sniplet right here on something you just said that has always been something in the back of my mind to remind people of. If you have an IRA or a 401k and you were married and divorced, make sure you change the beneficiaries, because if you kick it, your ex is getting your IRA when you die. So just make sure that you always keep your beneficiaries updated. Make sure like the percentages and stuff, if you've got like godchildren or whatever. I mean, and you don't have any spouses, because you cannot, right? The spouse has to inherit, if you have a spouse, for an IRA. Is that right? Unless you
Un-
that they sign
Unless they
off on
sign
it.
a waiver,
Yeah.
yeah, in advance.
Yeah.
Correct.
Yeah.
Mhm.
See, now that's good information there, Angela. Thank you. Thank you for your
Oh,
time
you're so
today.
welcome.
I love
My
this.
pleasure.
You know,
Yeah.
maybe we can have you back and we can talk about like inheritance taxes and we can talk about expat rules, which all these things that I think are
Sure.
fascinating. If you're allowed to, of course, or if you're interested in
Yes. Yes.
it.
All
Thank
the
you.
above. This
Thank
was
you. Thank
fun.
you. Thank you.
Okay.
Great,
Okay.
great
I hope
stuff.
it's
I really
helpful to
appreciate it.
your listeners.
It is, and I mean, even if the people who are listening are not in America, obviously the rules are different in every single country, but find out the rules, find out what the documents are. You can Google this type of stuff in the country that you're
Mhm.
in to find out what is necessary, but just please get your wishes documented. Something is better than nothing, but please, if you can save up to get an attorney, or just to start introducing yourself to attorneys to say, I'd really love to meet with you. What are your prices? Just start asking people,
Right.
because even just doing something like that gives you such a sense of peace also, because you're starting a
Yes.
process. And that's important. That's important that we take care of ourselves, because that is our job, is to take care of ourselves and not leave a mess behind.
Not leave a mess behind.
No more moss, less mess. All right. Thank you so much. Thank you for today. And hopefully you will come back.
Yes. Thank you. A pleasure.
Thank you. Take care. Bye bye.
Okay.